welcome to the Spinal Cord Injury Forum. My name is Jeannie Hoffman. I'm a clinical psychologist here in the Department of Rehabilitation Medicine and the director of the Northwest Regional Spinal Cord Injury System at the University of Washington. Tonight we are very pleased to welcome Josh Brothers, who's an attorney and partner in the firm Brothers Henderson, who will be talking about how special needs trusts can work for you. So please help me welcome Josh.
Thank you, Jeannie. It's nice to be here and nice to see all of you joining me on what actually turned out to be a relatively sunny day. And I know at least one person in the room is like me, a season ticket holder, the Sounders, not at the playoff match tonight. So appreciate you guys coming this evening and enjoying it. And you know, if we hear any big cheering, we'll know. I don't know if somebody's checking scores or not. Waiting to see it till he gets home. Okay. Well, good. Well, it's my pleasure to present a little bit on special needs trusts and talk to you guys a little bit about how these things work, to understand them a little bit better. And I will say I've done these presentations for all sorts of different types of disabilities, and I think the spinal cord injury community is a very unique one because it doesn't need 50% of what this is here for, because there is really often no cognitive impairment. So we're not worried about the financial management piece of things. We're more concerned about the coordination with public benefits piece. And so we'll start talking about all of that. By the way, too, if you have questions and you have a burning question, please feel free to ask. I know we're going to hold some time at the end to ask questions as well, but if there's just something you really, really want to ask that's relevant, please feel free to raise your hand. I'm happy to answer that. And of course, if you can't hear me too, please let me know. Okay, so we're going to start off by talking about just something in general. Where special needs planning comes up and where special needs trusts come up. And that area is really in the area of estate planning. So situations where we are planning for a loved one who may have a disability, a spinal cord injury, a brain injury, something along those lines. And this is really the basics of estate planning, just to be aware of. There are two basic types of estate plans that you'll see as the base plan. And we have a will and a revocable living trust. Both have their purposes. If you don't have one of those, the state of Washington and every other state is going to have a set of default laws that will apply to you about what happens to your money when you pass away. And those default laws are known as intestate succession or intestacy. And they're going to do things that you sort of assume that they're going to do. They're going to leave things to a spouse if you have one. They're going to leave ones to your children, grandchildren, your lineal descendants. And then if you don't have those folks, they're going to get farther and farther away in degree. So parents, siblings, nieces and nephews, grandparents, aunts, uncles, your cousins, you start getting farther and farther away in degree until eventually you end up with the state as the final one that's way down the line. That default can work very well in a lot of situations, but in scenarios where you want to change what that default is, you really need to look towards a will or revocable living trust in order to do that. These are the two most common estate planning documents, and they are really based upon which one you're going to do. Whether you're going to do a will or you're going to do a revocable living trust is really going to be based upon the probate process. Probate is just the process a person goes through to get their assets from them as someone who's passed away to whoever they want it to get to. And that may involve a number of different things, from selling real estate to funding trusts to selling stocks to dealing with will contests. There's a whole number of things that can come up in the probate process. And each state has its own probate process. Many states, for example, California, have a very complicated probate process, where if you end up in probate, people like me, people who do probate, they get paid a percentage of your estate. Wonderful state to live in for an attorney. Not so great for the end user consumer. So in the state of California, everyone is trying to get out of probate. And they use this thing called a revocable living trust to do that. And the revocable living trust, all it is it's a separate trust where you're moving all your assets into it. And because it's in this separate legal entity known as a trust, you avoid the probate process. So in many states, that's what we're trying to do. In the state of Washington, we're fortunate, though, because Washington really does have a very streamlined process. So the process for probate in Washington, very simple. It's a court proceeding, but the truth of the matter is that even the probate attorneys, we very rarely go to court anymore if there's a problem. If the appropriate planning's done, you can really avoid court completely. So when you're sitting there thinking and talking through, do I do a will or a revocable living trust, I will just say there are more pitfalls to revocable living trusts, and you really don't need it if all your assets are owned here in the state of Washington. Okay, so the next thing that people often think of when they think of their estate plan is estate taxes. So do I have an estate tax issue? So there are these things called the exemptions, and this is the amount of assets that one person can pass before the estate tax will kick in. Federally, you'll see that number is quite high right now. That is $11,400,000 per person. For a couple, you're right at about $23 million. So if you have that problem, come see me, please. But for the vast majority of people out there, estate tax planning on a federal level is no longer an issue. You're not planning for the federal estate tax. And the federal estate tax kicks in at a percentage of everything over that exempt amount. State of Washington, lower amounts definitely impacts more people. The number for 2019 is $2,261,000, and that's, again, per person, so really for two people. What I'd say at the state of Washington, there's some planning that you need to do if you get over that $2,261,000 number. It's pretty simple planning, but there is some planning around the estate tax you need to do. The thing that most people, I think, don't think about with this is that also can pull in life insurance. So if you have a life insurance policy on you, you have young children, you're likely to get over that $2 million mark pretty darn quick if you're trying to make sure you're accounting for those kids. So just something to keep in mind and how you plan for that number if it does come up. The other thing I'll mention, living trusts, revocable living trusts, people often think, I'll do that and I'll avoid estate tax. That's not quite the way it works. So you can't do a revocable living trust and just avoid estate tax. There are some ways to minimize, but that's not really one of them. So estate tax, again, for I think the vast majority of us, it's pretty simple planning, not terribly complicated, but do be aware of where those limits are to know how complicated the planning is. All right, so things to be thinking about for those people who are creating wills. The first thing to be considering is the position called executor. This is the person who is actually going to administer the will. They're going to make sure that the house gets sold if it's a family home and that's the primary asset like most people. They will make sure that that home gets sold, the proceeds get managed properly, taxes get filed, income taxes, estate taxes to the extent they're necessary. They also have the wonderful task, I think probably the worst task of anybody, which is to go through your house, figure out what to do with all your personal property. Should it be going to charities? Are we going to sell it? Is it going to particular individuals? All those sorts of decisions fall on the executor to make. So very short in time role, very intensive role. So executor is one role to be thinking about. If you're thinking about estate planning, think about who might be a good position for that. In addition, we've got the guardian, and for many of us, that is children who are under the age of 18, who's going to be making decisions for that individual. If we have a child over the age of 18 who is unable to make decisions for themselves due to some sort of disability and incapacity, if that's a brain injury, if that's a developmental disability, whatever it might be, a guardian is a bigger consideration because it's a very long-term thing about who is going to be making decisions for this person for the rest of their life. So guardian, another thing that you should be thinking about, someone you're allowed to nominate through your will, and again, very important for minor children as well as anybody over the age of 18 who might have a disability. Third is the role that we'll talk about the most, I think, which is the trustee. And the trustee really has a very distinct role of managing money. Who is it that is going to be managing the funds on behalf of another individual? And we'll talk about trusts in general in just a moment here, but there are a multitude of reasons you might set up a trust. But at its base, the idea is you're placing funds somewhere else to have those funds managed by a third party known as a trustee. So think about that, because that role, by the way, may be very different than the guardian. Your person who would be great at making decisions about medical care, that would be great at making decisions about where the person's going to live, might not be the best person to be managing a large sum of money. So thinking about the trustee, also an incredibly important piece of the estate planning process. So as I mentioned, as we start talking about special needs in particular, spinal cord injuries, brain injuries, there are a particular set of needs that we're thinking about. One of the primary considerations is really public benefit coordination. How do we coordinate with an individual's public benefits to make sure that a sum of money does not impact that person's eligibility for those benefits? They may be things they need, a number of different benefits, which we'll talk about in just a moment, but really thinking about how do we preserve those benefits. Second, we're thinking about that other piece, financial management. Is the person who we're going to leave money to, are they a person that maybe is vulnerable to exploitation? Are they a person that maybe has their own limitations on managing money? Do they have drug and alcohol issues? Do they have mental health issues? There's any number of reasons we might want a third party to manage funds on their behalf. But we're really thinking about financial management as well in addition to public benefits eligibility. Third is just decision making. Is this the person that's the best person to be making decisions? Do they know enough to know when they need help on the management of a large sum of money? So decision making is another large piece of this. And finally, just transitions between generations. How is it we're going to transition wealth? How is it that we're going to transition decision making? Very often for folks who have children with disabilities, the parents are the primary decision maker for a long period of time. What's that going to look like when mom and dad have passed away? How's that going to appear? How are we going to manage those relationships? Is the brother or sister the right person to do that? Maybe, maybe not. Is there a third party and someone outside the family? Maybe that's the appropriate way. So those are the things that we're really thinking about with special needs. As I mentioned, I think spinal cord creates a particular unique situation because oftentimes it's not the decision making, it's not the financial management. The big piece is really the public benefit eligibility. Not saying that those components can't be there, but that's very often what we're aiming at is that piece of things. All right, so, there it is. So we're going to turn now, as I mentioned, with the public benefits being such a big piece, to know a little bit and learn a little bit about the core public benefit programs that are out there and how all of those work together. So we'll start with just general Social Security benefits. That includes two real different categories of benefits. The first one is something called SSI, or Supplemental Security Income. SSI, just a cash benefit. It's intended to cover a person's basic food and shelter. And to cover a person's basic food and shelter, they're going to give you a whopping $771 a month. If you know a place within the Seattle area where you can use $771 to pay all of your food and shelter expenses, including your basic utilities, please let me know. Because it doesn't happen. But that's the number that we're looking at. It's not a huge number. The number does go up every year with inflation. I think I saw the inflation number just came out, or the cost of living just came out. It's like 1.6%. So it's not going to go up a huge amount, but it'll go up a little bit in 2020. But very often that's not really what people are concerned about with SSI. What people are concerned about with SSI is what it can lead you into, specifically Medicaid benefits, which I'll talk about in just a moment here. Now, on the flip side of that are just what I would term as general Social Security benefits. This is the system that when all of us are out there working, we're paying into that system. We put money in, we're entitled to get back out retirement benefits, there's a disability benefit associated with that, and there's survivor benefits for our loved ones, whether it be a minor child, whether it be a surviving spouse, whether it be a surviving child with a disability. There are these benefits that attach onto that. Really important to note that that benefit is dependent upon how much you've paid into the system. The more you pay in, the larger the benefit that comes out. That benefit right now is in excess of $3,000 a month at the maximum level. So if you've maxed out your Social Security, you're going to be making over $3,000 a month in retirement or upon a disability. And so obviously that's a much larger figure than the SSI figure, and oftentimes why people are looking to try and get down here rather than staying in SSI. And we'll talk a little bit about those benefits as well and how you get eligible for them. But just straight cash benefit based upon how much you've paid into the system. All right, so next we'll talk about Medicaid and Medicare. Yes? So let me just go back to this. SSDI is within the Social Security, this bottom part here. I've just termed it generally as Social Security Administration benefits, but SSD or SSDI fall within that lower category. So you're entitled to get SSDI because you've paid into the system. Social Security Disability Insurance. It's a world of acronyms, isn't it? So if you don't know any of these acronyms, please let me know. I'm happy to tell you what they are. All right, so Medicaid and Medicare. These two are really the basic medical component piece of things that you're going to find out there. They're the basic medical benefits that you're going to find available to individuals with disabilities. Two pieces on the Medicaid piece. The first piece is really that medical component. It's the medical assistance portion. And that medical assistance portion is intended to pay for anything that's considered medically necessary. So prescription medications, medical equipment, hospital visits, doctor visits, all of that falls within the general description of medically necessary. So big component of things for folks. The second component is equally as big, if not bigger, and that is long-term care. Long-term care is the benefit that is out there that will pay for care provider support either in the home or in an out-of-home placement such as an adult family home. Both of those Medicaid benefits, important to put them in that sort of category and in your mind. But long-term care, it's a huge piece of things. The average cost of care for a Medicaid facility, which is paying a fraction of what we would pay privately, by the way, but the average cost of care at a Medicaid facility is right around $10,000 a month right now. I think the number is like $335 a day, something like that. So it is a huge number. So just trying to imagine paying for that, and you can all of a sudden see why, boy, it might make sense to try and preserve this benefit. I don't know how many of us want to be shelling out $120,000 in care every year, but it's a large number. All right, so, and by the way, too, I would mention it is both in-home and out-of-home placements. So this doesn't mean you need to go to the nursing home facility that's run through Medicaid. You can have in-home care providers, and as a matter of fact, it can really be anyone who gets qualified through the state to provide that care. Very frequently, we find it is family members that are getting qualified to serve as the care provider for individuals with disabilities. So family members can come in and serve in that piece. The one caveat being that if you're a parent, you cannot be the care provider, paid care provider for your minor child. Once they turn over the age of 18, you can in fact be that care provider, but under 18, you cannot be. All right, so Medicare is the other primary medical benefit that you're going to find that's out there. Medicare works a little bit more like a traditional insurance plan where we have premiums, copays, and deductibles, so we have out-of-pocket expense associated with your Medicare benefits, but Medicare is going to cover hospital visits, doctor visits, prescription medications, and durable medical equipment. So pretty broad coverage, but out-of-pocket expense. The one main thing that is missing with Medicare is the long-term care benefit. Long-term care is not something that is offered through Medicare. There are short-term rehab pieces to Medicare, but not the long-term care piece that an individual is potentially going to need on an ongoing basis. Yeah. So the question was, if you're using both Medicaid and Medicare, what's the relationship and how does that work? So the way that that works is you're thrown into something that is called dually eligible, meaning you're eligible for both benefits. And the Medicare serves as your primary insurance. So Medicare is primary. That's what gets billed as the primary. But Medicaid comes and fills in the gap. And they are really that secondary insurance to ensure that you don't have premiums, you don't have copays, you don't have deductibles. So your out-of-pocket expense either goes away completely or is significantly limited on how much you actually have to pay towards your medical care, even though Medicare is your primary. Make sense? Did that answer your question? Okay. If you have other questions about it, you can ask me in a little bit. Yeah.
Eligibility is based on income?
Oh, well, just a wonderful transition to my next slide. So we didn't talk at all about eligibility because I have a whole slide here on eligibility. This is the most complicated slide you'll see, by the way, and I'll walk you through it here. So you'll see here what we've done is we've lumped together SSI and Medicaid, and we've lumped together those general Social Security benefits and Medicare. And the reason that we do that is because the eligibility criteria are similar for those on the left side of the board and for those on the right side of the board. So we'll start off by talking about SSI and Medicaid and eligibility for those benefits. You'll see two different categories of how we classify things. The first is SSI and what I would call traditional Medicaid. The second is Medicaid Expansion. So for SSI and traditional Medicaid, we're really based upon two components. The two components are you've got to be either disabled, blind, or over the age of 65. And then their second is that there's a means test, meaning they're looking at income and resources when determining eligibility. For the disability definition, just because that's how most people get into this as a starting point for the people I'm chatting with, disability is really based upon can you go out and work, or do you have a condition that prevents you from doing so? And it's an index number. They say it's what we call, by the way, the term, yet another acronym for you, Substantial Gainful Activity, or SGA. And SGA means essentially $1,220 a month. If your condition prevents you from going out and working and earning that amount, you meet the disability definition. I will be the first to tell you that it is way more complicated what Social Security is going to do to get to whether or not you meet that disability definition. There's all these listing impairments where they have, if you meet all the conditions of one, you qualify automatically, or there can be a functional equivalent or some pieces of each component of the listing impairment. It is so complicated that there are attorneys that do nothing but Social Security disability work. That's all they do because it is such a complicated area. But that at its base is what they're looking at. Can you work? So disability means all sorts of different things for all sorts of different programs in all sorts of different ways. For our purposes, it's a work-based definition. Okay, so we'll come back to SSI and Medicaid. The second component here of SSI and Medicaid is that means test. And the means test is really looking at income, so what do you have coming in the door every month, as well as assets. What do you have in your bank account? The income really depends on the source, on how it impacts those benefits. So for purposes of SSI, if you earn $2 after some exclusions, it's going to start knocking your benefit down by $1. So it's a 2-to-1 reduction. For every $2, $1 comes off. Unearned income, which is exactly what it sounds like, anything other than work, so interest on a bank account, gifts, settlements, inheritances, all of that counts as unearned income that would reduce dollar for dollar after the first $20. So if I have a disability and I'm on SSI, and my mom decides she's going to give me $100 and put it in my bank account, that $100 is actually going to reduce my SSI, $20 exclusion, down by $80. So all of a sudden, that $100 turned into $20 pretty darn quickly. So you start to see, by the way, where some planning can really help to avoid some of these things. And the third type of income I'll mention is something called ISM, acronyms, in-kind support and maintenance. What in-kind support and maintenance is that remember SSI covers your basic food and shelter expenses. If somebody else is covering that expense for you, for example, you're living with somebody else and they're not charging you rent, or somebody else is paying for your rent and utilities, somebody's paying for all your groceries, that is in-kind support and maintenance. Somebody else is paying for that thing that SSI otherwise would. They can reduce your benefit by up to 1/3. They cannot reduce it by more than 1/3, but they can reduce it by up to 1/3 of the benefit. So in-kind support and maintenance, that'll be an important concept, by the way, as we start talking about this stuff. And then the second is this asset test. It's really a $2,000 limit to what you can own. They look at that asset test at one point in the month. It's midnight on the first day of the month. What do you have in your bank account? What do you own? If it is more than $2,000, you are ineligible for that particular month. So that $2,000 limit, important to realize. And note, too, that there are a number of things that don't count towards the $2,000 limit. A home of up to $585,000 in equity, that's a Washington State number. The federal number is 500. If anyone noticed, living in Seattle is not exactly cheap, so we have a higher number. So $585,000 in equity, as long as it's your primary residence. Can't be a rental. Primary residence, though, that's going to be exempt. Same thing goes for a vehicle of any value. So a wheelchair accessible van, for example, would be an exempt resource regardless of the value of that vehicle. It's not going to count towards the $2,000 limit. In addition, there are certain things, personal goods, household effects. They're not going to come in and inventory your house and say, you've got furniture, clothes, a television, a computer, and all of that's worth more than $2,000. You're off SSI. Nope, you get to hold that stuff. The one sort of thing I will mention about this is that if it's a very obvious investment, they're not going to allow that to occur. If you have a Monet hanging in your dining room, and they come in and see that and they say, oh, a Monet, and you're like, no, that's a household effect. They're probably going to say no, and say, no, that's an actual investment, we're going to count that. But for the most part, really it's personal goods and household effects. And then lastly, are special needs trusts and ABLE accounts. This is where we fit in when we start talking about special needs trusts and ABLE accounts. How do we qualify for SSI and Medicaid? Okay, so traditional SSI and traditional Medicaid, that's our sort of overview of eligibility for those. In addition, we have something new, which is called Medicaid Expansion. And what Medicaid Expansion is this is something that came with the Affordable Care Act or Obamacare, whatever you want to call it. And what it is that the states had the option after it went to the Supreme Court, they had the option to accept Medicaid Expansion. And Medicaid Expansion did exactly what it said. It was increasing the number of people and the eligibility for Medicaid. It all of a sudden did away with that disability test, so no longer did you need to be disabled, blind, or over the age of 65. We're not talking about that anymore. It did away with the resource test. It said no longer are we going to look at what's in your account and what you own. The only thing that we're going to look at is your income, and a specific type of income, something called Modified Adjusted Gross Income, or yet another acronym, MAGI. And it's basically the way to think about it is your taxable income. If your taxable income is over 138% of the federal poverty level, under 138% of the federal poverty level, you are going to qualify for Medicaid Expansion, and you're going to have medical coverage. What is missing from this, though, from that medical coverage, is long-term care, with one exception. It's a pretty narrow exception. Long-term care is not going to fit into this. So keep that in mind as you're thinking about eligibility for the benefits. Yes, we can get you to medical eligibility if you're over the $1,220 a month and you have resources of over $2,000, but we really can't get you there with long-term care. Okay, any questions about that? The right-hand side is way easier, by the way. And the right-hand side is just that same disability definition, blind or over the age of 65, and then it's, do you have the requisite work history? For purpose of Medicare, I put it up here. It's 20 of the last 40 quarters prior to disability. There is a period of time you need to wait that's about 2 years before Medicare kicks in. And during that period of time, oftentimes Medicaid serves as the gap. COBRA insurance can also serve as the gap that gets you from to Medicare eligibility. But that's what Medicare is based upon. It's not based upon any sort of income or resource test. So if you're on the right-hand side of the board, special needs trusts are not a planning tool to help you preserve eligibility. It's really only if you're on the left-hand side of the board in that SSI and Medicaid category where we really need to do some planning. Yes? Yeah, so HWD, healthcare for workers with disabilities. I said there is a caveat to long-term care. HWD sort of fits in, it's a Medicaid program over here. And what HWD says is that we're going to allow people to work and earn money who meet a disability definition and still stay on their Medicaid benefits, but they're required to pay out of pocket. So they're required to participate in the cost of their care. HWD clients, by the way, are the one exception on how you can get through Medicaid Expansion onto long-term care. All right, so let's get into the trust discussion a little bit here. All right, so the basic sort of idea of a trust. This is just trust in general to make sure we all understand, because I think as an attorney you start throwing around the term trust and you assume everyone knows what you're talking about when nobody really does. But the basic idea of a trust is really having a whole separate legal entity from yourself. So it's as though if I was sitting here We're all sitting around a table. I would be sitting in one chair. My trust would actually be sitting in a whole separate chair. It's going to have its own tax identification number, just like we all have our own social security number. It's going to report to the IRS on its own. For all intents and purposes, it is separate from me. It is there to benefit me, but it is completely separate from me. Some roles within that trust to be aware of. The trustor, the settlor, or the grantor all mean the same thing. This is the person who sets the trust up. So the person who establishes it, gets this whole thing set up. The trustee is the person who does the management of the assets placed in that trust. The settlor, trustor, grantor does not have to be the same person as the trustee. It's a very common scenario where we have someone setting it up, but someone else managing the funds. So trustee, I would say probably the most important role, other than the beneficiary, who is the person who benefits from the trust. So the person that the funds are placed in the trust for is known as the beneficiary. So just some terms of art. By the way, at its core, if anybody notice what this word is, trust? Yeah, that's the idea. We're trusting someone else to manage the funds on our own behalf. So it really is an important relationship, in particular with that trustee. I think that trustee relationship, people come in and they see me and they talk to me, and I'm the one who drafts a trust agreement. So that's the set of rules that are going to apply to the trust. But I'm not the one who you're going to deal with on a day-to-day basis. That's the trustee. And that trustee relationship, I think, is as important as any relationship you're going to have if you do have a trust. All right, so sort of 4 basic functions of any type of trust. Number 1, administrative tasks. So making sure you're getting accountings, making sure taxes are being filed, keeping trust records, maintaining bank statements, all of that sort of stuff falls on that sort of administrative tasks. So they're going to be in charge of administrative tasks, somebody who needs to be pretty detail-oriented on those things. Number 2, safeguarding the money. There may be reasons why you want to make sure funds are held in a trust and not in the individual's name alone. The way I sort of think about it is that you have your money, it's on one side of a wall, the beneficiary is on the other side of the wall, and that beneficiary can't get through the wall to get to the money. Instead, on that wall, you have your guard, which is your trustee, manning that wall, making sure that it's protected. And the only way the money gets from one side to the other is by the trustee deciding to do so. The beneficiary cannot directly access the funds. Important for 2 reasons, by the way. Number 1 is just there might be a concern with that person managing money themselves. But number 2 is that third parties can't get to that money. So people trying to take advantage of the person, creditors and debtors that might be out there. This can help prevent creditors and debtors. New spouses, by the way. There are a number of reasons people set these trusts up, and people with wealth often set them up to avoid those creditors for their children. So really, there's a big safeguarding function to this, which can be frustrating, by the way, because you're going through a third party, that trustee, to help you with these pieces. But it is an important component of any type of trust. 4th, financial management. How are we going to invest the money? Are we going to put it in the stock market? If so, how are we going to allocate it? Are we putting it in laddered CDs? Is it a savings account? Is it all cash? What are we doing in order to maximize the rate of return and to invest to meet that person's own abilities? And then 4th, our distributions. How are we going to spend the money on behalf of the beneficiary? Are we going to pay for them to go to college? Are we going to pay for an experimental treatment? Are we going to pay for a trip? Are we going to buy a wheelchair accessible van? All of those decisions fall on the distribution side of the trust. The types of trusts that you're going to hear about, so types of trusts, there are all sorts of different types, special needs just being one type of trust. Really, all they are is there's some instruction to the trustee on how they're to perform those duties. Perfect example is grandparents will often set up trusts for their grandkids, and they only want the funds to be used for education. That's just an education trust. It's a restriction on distributions. How are you going to spend money? Only on education. Special needs trusts, no different. But special needs trusts, the main focus of them is going to be on distributions. All right. So what is a special needs trust? So two main components, as we've already talked about. Number one, financial management, and then number two is public benefit coordination, in particular SSI and Medicaid. If there are questions about Section 8, I'm happy to answer those. Those are kind of a unique situation, but can also be meant for coordination with Section 8 and other means-tested benefits. But SSI and Medicaid are kind of the main ones we're looking at. Yeah? With what's the Section 8 deal? So the story with Section 8 is that Section 8 benefits really depend on what they're an income-based benefit, and they're really dependent upon what the source of that income is. Generally speaking, the income causes eligibility problems, but if it's a particular exempt source of funds, it won't count. The two most important ones to be aware of just right off the bat are inheritances and settlements and judgments. Those are two exempt resources. So there's gotten a whole thing that's happened with Section 8 over whether a special needs trust is exempt or not. And the only case that's out of there is a case out of Pennsylvania, and the case said it depends on the source of the money. If it came from one of these exempt sources, the trust is exempt as well. If it didn't, then the trust is not exempt.
Is Section 8 for housing?
Yeah, sorry, for those of you who don't know, Section 8 is a housing benefit, and what Section 8 will do is that it's a benefit, it's an income-based benefit. People with disabilities get some priority with that, but it is a voucher you can take to various landlords and use as partial payment of rent, and then you're expected to participate in the rent as well. Okay, so really, a special needs trust is not so much defined by what you can pay for. Remember I said the focus is on distributions? Really the focus is on what you can't pay for. The general concept being that you don't pay for general sort of food and shelter expenses and general primary expenses. So everything over and above, and I'm going to get into the extent of my, my PowerPoint abilities right about now. So at your base, you really do have this basic food and shelter expense. That's your sort of basic benefits and your basic medical costs. Everything above and beyond that are what we consider your extra and supplemental expenses. The concept is that SSI and Medicaid will cover that base. So if you qualify for SSI and Medicaid, your base benefits, your basic needs are being met through those. And the Special Needs Trust will come in and pay for everything over and above that, extra and supplemental. But the basic concept of this trust is, generally speaking, don't pay for food and shelter for the individual. The concept is that if the trust specifically says, trustee, you are instructed to not pay for food and shelter, then SSI and Medicaid can't come in and say, you've got another source to pay for these things that we would otherwise pay for. So that's the basic sort of concept. I will say again, there are caveats all over the place, but if your trust is drafted correctly, your trustee can actually avoid that restriction as long as they, number one, understand what the impact is on SSI and Medicaid, or number two, if you don't qualify for the benefits, we don't need those restrictions anymore. So the trust generally, if you have somebody who knows what they're doing, is going to be drafted with enough flexibility to actually allow for food and shelter expenses, but at its base, it's going to say don't do it. Okay, so that's the sort of basic concept of the Special Needs Trust. The other thing I think that this is probably one of the more frustrating things traditionally for folks who have spinal cord injuries, and that's how distributions come out of the trust. So if you think of my money bags here, this is our trustee walking around with a big bag of your money, our individual beneficiary, and then they want to go on a trip, a plane trip. So the general concept would be, traditionally we give the money to the individual then gives that money to the airline. The problem is that we've taken care of the resource test by creating the trust over on the left-hand side. That's done nothing for the income test. If we take that money and give it to our beneficiary, just hand them money, we've all of a sudden created an income problem for that person. And that income is going to cause them to lose eligibility. So we generally try and avoid putting money directly into their hands, and instead, the trustee is going to make a direct payment to the airline. Pay them directly, a direct payment. That becomes a huge source of frustration for folks who are very independent. If you're independent, you're fully capable cognitively, this is going to be maybe a frustrating thing. I can't have access to any of my own money. I will say that there are some new ways that we can sort of get around this and deal with this, but at its base, this is the idea. We really want to avoid direct income to folks, to avoid an SSI and Medicaid income problem. Okay, so those are sort of the basics of the trust. Now we're going to get into some of the details of this. So number one, the source of the funding is going to matter on what type of special needs trust. So you have two different basic types of special needs trust. If it is your own assets, so own assets or assets that you have a legal right to, even if they never came into your possession. So if you're an individual who has a spinal cord injury, you had assets before then, and you're trying to figure out what to do with them, they fall into this category. If you're an individual with a spinal cord injury or a brain injury and you have a lawsuit, even if you never take possession of that money, you are the one with the legal right to make that claim and to pursue that action. It falls into this category. If you're a person with an injury who does not, or whose parents left them an inheritance or grandparents and didn't do any planning, your direct receipt of that money, even if it never leaves the probate and comes to you, if you were legally entitled to those funds, you fall onto this category. So with that, you end up with something called a self-settled special needs trust. And there are two types, D4A and D4C. And I'll tell you more about those, but those are basically citations to the federal law. The other category are really assets from a third party. So a parent or a family member does some really significant planning. They know what they're doing. They plan ahead. They actually technically disinherit their child in favor of the trust. The child never had any legal rights to the funds. You avoid them completely. You fall into this third-party fund. Same thing goes with gifting. So gifting that's done in there, a really common place I've seen these done in the spinal cord world is with GoFundMe accounts or with donations. So there's fundraisers, donations that come in. If you plan it correctly and you set those things up correctly, we can fall on this right-hand side. And as you're going to see in a few minutes here, if you can, you want to fall on the right-hand side. And that is just called a third-party special needs trust. That's all it's called. So two types, two general types, self-settled and third-party. So the self-settled or the D4A trust, so this is the first type of self-settled trust. The 6 requirements are, number one, this trust, the beneficiary must be under the age of 65 when it's created and funded. Second, they must meet the disability definition when we create and fund the trust. This isn't something that's meant for us to plan for our disability as we age or at some point in the future. Third, it has to be irrevocable, meaning that the individual with the disability cannot have the ability to revoke the trust at any point in time. There are outs, there are ways to terminate it early, in particular if the person no longer meets a disability definition, but generally speaking, they can't directly have the ability to revoke. Fourth, I think this is a big frustration for people sometimes, is there's something called the sole benefit rule, which says that only the beneficiary can benefit from the trust. So any distribution that's made from that trust has to be justified as benefiting that individual. So that becomes a really big deal with kids, really big deal with spouses, because you all of a sudden can't distribute money out to say, hey, I want my 3 kids to go on vacation with me. Could you pay for a care provider to go who happens to be your spouse? Sure, because that benefits you. But when you start doing expenditures that benefit other people, it causes big problems with SSI and Medicaid. Fifth is that the trust, so the settlor or grantor of that trust, can only be, and this is the new one, an individual. So this came around in, I think, 2017 or 2016, the end of the year. And now an individual can create their own special needs trust. You can't be the trustee, but you can create the trust yourself. Or a parent, grandparent, court, or a guardian can create the trust. So those are the only entities that can actually create this. Can't have a friend create it for you. Can't have a spouse create it for you. It has to be one of these actual entities that are up here. And then sixth is something that doesn't necessarily impact the individual during their lifetime unless they terminate the trust early, but it's something that impacts them when the trust terminates, which is that Medicaid keeps really good track. They keep this log of everything they have paid out during the course of the individual's lifetime. And when the trust terminates, which is typically when the person passes away, Medicaid's going to come with that log to the trustee and say, by the way, here's what we paid. we want to get reimbursed for those funds that we've paid out during the course of that person's life. So Medicaid reimbursement is going to apply to these trusts. Again, I said it doesn't really impact the person. It impacts who they might want the funds to go to when they pass away. It can impact them on early termination, but really, oftentimes we just end up leaving funds in trust and not worrying about it. So Medicaid reimbursement becomes a bit of a big issue. I will say Medicaid reimbursement, not exactly the worst thing in the world. I mean, if you consider what Medicaid's doing, they're essentially saying, we're going to give you the money. If there's nothing there at the end of the day, we don't get to collect. Not only are we giving you this money to pay for this with it not being secured, but we're also giving it to you as an interest-free loan, essentially. They're not charging you interest. They're giving you this. And if you've ever looked at your medical bill, what the doctors charge is, say, $100. What your private insurance, they're going to negotiate a rate, and it may be $60. Medicaid has so many people, they negotiate an even lower rate. So they may be paying $29 out of the $100 for a particular service. So you're also getting a discounted service. So it's not a terrible deal. It's not a terrible trade-off, but it is a trade-off that you have to be aware of when you get into these trusts. So Medicaid reimbursement is a big part of these as well. Okay, so there is another type of trust that falls into that self-settled trust. We're going to call them pooled special needs trusts, D4C, reference to the federal law. Again, I'll put that up here. Very similar requirements with some notable exceptions. So I'm just going to put these all up here. So you'll see the last four are going to look familiar. The person's got to be disabled. It's got to be irrevocable. It's got to be for the sole benefit of the individual. The account has to be established by one of those individuals that we mentioned earlier. And sorry, the fifth one, Medicaid reimbursement applies to this trust as well. The big difference between this trust is that this is a trust that actually already exists right now. It is what is called a pooled trust because it has many beneficiaries who are pooling their money together for purposes of investment and management. So we're pooling all our money together. The concept being is that we can do it cheaper. You don't have to pay someone like me to draft a new trust. We can do it cheaper, and by bringing it all together, the management fees are actually less expensive than you would see with an individually created trust. Really good for smaller sums of money. So if there's, for example, settlement where you're hitting limits or there's not a whole lot there, or small inheritance, really great solution for that. Each account has to be a separate account, so they're not going to be accounted for, and you're not going to sort of commingle for other than for purposes of investment. So you get your chunk of the investments, but the fact that another beneficiary pulled money out of the account to pay for a wheelchair accessible van is not going to affect your account. So all accounted for separately. And then lastly, only a nonprofit can serve as the actual trustee of these trusts. So the nonprofit's going to have, they might have like 2, 3, 5, 8 different investment options, but everyone who picks those is going to have that investment option. So if you're looking for something very specific for your situation to say, hey, there's something I want invested in or a particular investment model, it's going to be less specialized for you as an individual, but it's going to have the general options that are going to best meet your needs. So. But yeah, you're not going to be able to invest in that. You're probably also, by the way, in most of these, not going to be able to invest in real estate. So you're not going to be saying with a pooled trust, I'm going to put up my home into this trust, or this is going to buy me a primary residence. We're generally talking about real investments in the stock market. So yeah, so great question. How is that working with the nonprofit? So the nonprofit is serving in the role of trustee. So the nonprofit serves as the trustee and manages the money. That's it. Yeah, exactly. So the nonprofit may actually have nothing to do with the particular disability or injury or anything that relates to this individual. They just happen to be a nonprofit that set up a pooled trust. Yeah, and there's only a handful of them, which we're going to talk about in just a minute here. One of which I'm going to talk about because I'm the presenter and I get to talk about it. And we'll talk about those, a few of the options that are out there. But I will tell you, the one thing to watch out with these pooled trusts, this is less a problem here than it is other places in the country. There are these nonprofits that have been set up, and those nonprofits are really individuals saying, how do I capitalize on this market? And they set up a nonprofit with the specific concept of creating a pooled trust so that they can create income through working as trust officers and being the people that are employed through that. There's only really a handful of them that have traditional, really true nonprofits, which I'm going to talk about right now. So these are the ones in Washington State that you're really going to find that are out there. The first one, which is the one I'm going to talk about in a little bit more detail, is the Pooled Alliance Community Trust, or the PACT. The PACT is run by the Brain Injury Alliance of Washington. So that's what that's for. Again, it's not specific towards people with brain injuries. It can be any type of disability, but the Pooled Alliance Community Trust is one of those. The second is going to be an organization called Lifetime Advocacy Plus, and they've had a pooled trust that's existed for many years. The third one is really a sort of a very unique one to Washington State. It's called the Developmental Disabilities Endowment Trust Fund, and that fund, though, is specific towards people that are Developmental Disability Administration clients. I'm not going to talk about that in too much detail because that's probably not very specific to the spinal cord injury community. But it is one that's out there. And then we've already talked about there are other regional options, there are other national options. Once you start getting beyond these three, I would be cautious about the nonprofit to really see what it is. And that's not to say they can't do a good job, but I find the fees are going to be higher. For example, the fee for setting up the PACT trust, $750. The fee for setting up one of these other larger ones that I've seen nationally, $3,000. If you're going to pay $3,000, you might as well pay someone like an attorney to draft one for you specifically. Yep, you can pay the setup fee out of the funds that are going to be going into the trust. And that's a very common situation, too, for that to happen. Both for an individually created, so that self-settled trust, as well as the pooled trust, that the money would come out of whatever the source of funding is going to be. So, again, I said because I'm up here, I get to talk about the PACT a little bit more. And the reason, by the way, I'll give you the full disclosure on the reason I'm talking about the PACT is that I serve on the Brain Injury Alliance of Washington on their board of directors. So I have a vested interest in seeing this do well. I have no personal interest. I get nothing out of doing this other than the fact that I get to see it do well. And I helped create the thing. And so I thought we needed another pooled option. And so we got the Brain Injury Alliance on board to do this. And so I thought it was a good thing. And so I get to talk about it. So again, want to be clear, no financial benefit or any other sort of benefit to myself other than the joy of knowing that your funds are being managed correctly. But the Brain Injury Alliance is the technical trustee, but they've contracted out for the vast majority of the services. The trust manager is a gentleman named Robert Zilke. He's an attorney who does nothing but management of trusts. He's going to be the person who's the main contact doing all the distributions, one of the primary contacts for the individuals. The investments flow through UBS Financial Services, and then the back-end accounting is through this organization called TrueLink Financial. So those are just some of the folks involved with it. The PACT, just a few things about it. Number one is just true with all pooled trusts, is that you create this joinder agreement. And that joinder agreement is going to be the thing that you're going to sign and create that gives the trustees some idea about who you are. Is there a legal representative that's involved that's different than you? What generally do you want done with the funds? How do you expect to see them spent on your behalf? How long do you see them lasting? And give them some really basic general information, but every pooled trust is going to have a joinder agreement associated with it. And then basic fees, I mentioned this, there's an enrollment fee, there's an annual percentage fee, and then there is a distribution fee for everything over $1 a month. And then as I mentioned, there's investment options. There's currently 3 investment options within the PACT. One is a cash equivalent, really meant for people that are trying to park their money somewhere. It's maybe a small sum of money. Saying, boy, this is more of a hassle than it's going to be worth, and it's going to cause an impact on my benefits. Cash equivalent, if you're expecting the money to come out, for example, buying a van or maybe putting a down payment on a home, those sorts of things, great option for that. And then they get more and more sort of investment heavy depending on what the person's needs are. So 3 different investment options on that. And then I'll just put the general contact information, the website, email and phone number for PACT. Yeah? So for this one, there's about 35, I think, was the last count. So it's relatively new. I mean, it's like within the last year. And they got up to 35 pretty quickly. So it's growing pretty rapidly. Just to give some comparison, by the way, that Developmental Disabilities Endowment Trust Fund, I should also mention I was on the board for that for a while, but that was appointed by the governor, and so again through the state. But that one, that was created in 2000 or somewhere thereabouts. They have about 2,000 people. So you're going to see, I think, pretty exponential growth on this over time. All right, so really common uses for these types of funds. Unexpected disability, so spinal cord injury. Imagine that's pretty unexpected for most people. But that spinal cord injury, unexpected disability, if you've built up resources and assets, this is one of the ways that you might look to use in order to plan for your future. Wages, so money's coming in, we're just not spending it fast enough. We might use a first-party special needs trust to help deal with the wages that are coming in. Inheritance, direct inheritance, and then settlements and Social Security back payments and settlements and judgments are really kind of the main ones. So the Social Security back payment is sort of an interesting one. What happens, I don't know how many of you have been through Social Security, but if you apply for example, SSDI, and you submit the application, and they put you through the ringer trying to determine whether or not your disability, maybe you have to go to a hearing. Hearings, by the way, from the point you start until the point you actually get a hearing is like, I think about a year now. And then you add on to that the time that you spent up to that, as well as the time to get a decision, which could be another 3 or 4 months, and pretty quickly you're at like 2 years. And then all of a sudden they hand you a check and say, okay, well here's what we owe you, because they'll pay you back to the date of application, and they'll say, oh, by the way, spend that within 9 months or else you lose your Medicaid. And so you've got this big lump sum of money, and so you might look towards these options for that. No, so you can't use it to avoid income. But for example, the way that this often comes up, someone's making, let's say they're making $1,000 a month. So they're still meeting that disability definition, but they're not spending the money quick enough to keep below $2,000 each month. So each month they're struggling, they're like, we're just wasting money. We could be saving it. They instead might say, all right, we're going to take $300 every month and put it in there and start funding a trust. Okay. All right, so let's talk about third-party special needs trusts. I think this one's, again, hopefully relatively simple and straightforward. A lot less complicated than first-party special needs trusts. So again, remember, this is assets of anybody other than the beneficiaries. So family members, donations, fundraisers, all of that fits in this category. They have to be irrevocable, so the person still can't have the ability to revoke the trust. But none of the other D4A or special needs, first-party special needs trust restrictions apply. Means no Medicaid reimbursement, anyone can establish it. They could be 90 and create this trust. So no real restrictions apply to this, and I will say Social Security and Medicaid look a lot less closely at this, and the reason is pretty obvious, is that they're not getting paid from what's left in this trust at the end of the day. They don't care as much about how these trusts are administered. They don't care about how these trusts are written as much. So much less scrutinized, and certainly much more beneficial for the individual. They get to control where the funds go when they pass away. The funds really can be set up at any point in time. So I think for family members, this is a really important one to keep in mind, and to keep in mind for planning, which is you really want to try and do some planning to get into the third-party special needs trust side of things. You can do no planning for an inheritance or gifts or things along those lines, and we can deal with it on the first-party side, but it's definitely much preferential to end up in third-party land. And then I won't talk about this too much, but it can either be embedded within a will, or you can have a standalone document that you create right now. But I won't talk too much about this at this presentation. Okay, so common uses for these trusts. Pretty obvious: estate planning, will and estate planning. Gifts, so you want to gift somebody to an individual who has a disability. You could put it into a third-party special needs trust and still allow that person to qualify. By the way, the PACT and the Developmental Disabilities Endowment Trust Fund both have third-party special needs trust component. I think LA Plus does too. So there are options out there if you don't want to pay an attorney to draft a trust that would get you there. So gifts, another really common place for these. Extended family planning, so you know you've got family members that are out there. It's not at all uncommon that we know there's aunts or uncles or grandparents that are going to want to leave money. We might create a trust that really has no money in it right now where all the family can sort of feed into. Spouses with disability is another very common situation that spouse is trying to do their own estate planning to think about how do I make sure I leave money and allow this person to qualify in the future. Okay, so special needs trust administration, I won't talk in too great of detail on this either, but I'll mention a few things. First of all, the trustee is going to have some fiduciary duties that they owe to the individual, meaning that they owe them a duty of loyalty, they owe them a duty to act in their best interests. They're there for that individual, not for themselves. So they owe a bunch of fiduciary duties to that person. Really important for that trustee to understand what those duties are. Again, the direct payment thing, you got to be aware of that. Again, distributions to the individual. What's going to happen if you make distributions to them? How is that going to impact their benefits and understanding what benefits they're on? There's some specific things that come up with ownership of real estate for a trustee they really need to understand and know about. And then tax treatment. Trusts get treated differently from a tax perspective. And the thing to keep in mind is that it's very similar. It's a graded tax level, but it's very condensed. So by the time you're at $13,000 worth of income in a trust, that trust is going to be taxed at the highest level, at the 35% plus level. So important to know how that works. There are some ways, again, you can get around that. There's certain trusts that it doesn't apply to. For example, a trust that is created with a person's own money, so the grantor, that first party, that self-settled special needs trust, those trusts have some exceptions to them, and it's not going to be subject to that condensed tax treatment, but really important for the person to understand what that means, or quite honestly, to know enough to hire an accountant to help them with it. And then these can really be, they can be very highly intensive trusts. So you've got to make sure that the person understands the disability. How is it that the disability affects this person? So dealing with somebody with autism is much different than dealing with somebody with a spinal cord injury, and they need to understand those differences. In addition, they need to understand those public benefit programs. What programs are they on? Which side of the board did they fit on? To understand what the impact of benefits is going to be, what the restrictions are that are going to apply to the individual. So understanding those programs. Family interactions is huge. You may not want your little brother being the trustee of your special needs trust. That can create huge friction and huge problems. So understanding those family interactions and dynamics, even for an independent trustee, understanding the dynamics between the spouse or the siblings, the adult siblings, and understanding how all that fits together. Parents becomes a huge issue. I think in particular with spinal cord community for kids with spinal cords who were injured when they were under 18, as they start to get older, what's the interaction now between the trust and the parents who had traditionally been the contacts, and how is that going to work, and how's the transition going to work? So huge, fun family dynamics that are there. This is about as close you get to family law, by the way, without actually being in family law, is doing these sorts of things. And then they can be very complex. So the laws are constantly changing, the rules are constantly changing. That Social Security has these internal policies that they change on a regular basis that deal with special needs trusts. So a person really needs to keep up to speed on this or know how to keep up to speed on it. And so I really I do think about it, about who is the most appropriate person to serve. Family members might be the right answer for a lot of situations, but quite honestly, you may be looking towards professionals in a lot more of them. I find myself more and more advising families, look towards the professionals, because the people you have that are here that you want to serve in this role, there's either a family dynamic problem or there's a problem with this person understanding how to manage the trust and what's going to happen. Because there's so many traps out there for trustees to step into that they oftentimes don't know what they don't know, and it's too late. By the time they come to somebody like me, it's too late. Things are screwed up and we've got to figure out how to fix it. The thing I would say about family member trustees, I think they can be fabulous, by the way, too, but the best family member trustees are the ones that know that they don't know a lot of stuff, and they go out and get advice about from an attorney about, boy, we're thinking about making expenditure X. Should we do that? Talk to an attorney, and they know enough to get some advice before they do things that could screw things up. So professionals can work great, family members can work great. I'd also mention you can split things up. So you can divide between, for example, one person doing the distributions and the other doing the investments. Maybe that works between a family member and a professional, or playing to the different skill sets of different family members. You can also have two people doing everything, or a person and a professional doing it all together. So great way for a family member to have some insight, but the backing of a professional. Yeah? Yeah, the nice part is that the person who sets this trust up gets to control the terms of the trust, meaning they get to set this up. And I will say, we do have a provision that says family members will charge at no or little fee, but in probably 90% of the cases, we end up dropping it out for that exact reason, is that I want the family member to have the ability to get paid. They don't have to be paid, but I want them to have the ability to get paid if they step into this and they're like, whoa, this was a way bigger deal than I thought this was, and now all of a sudden I'm spending 40 hours a month working on this trust. So yeah, there will be compensation provisions, both for professionals as well as for individuals. And the last thing I'll mention on this is that you have a family member, you think they're really well-intentioned. They're not going to be great at day-to-day management, though. They're just not the person that's going to be able to keep track of the accounting, to direct investments, to keep current on what's going on with all of the public benefits. That doesn't necessarily mean that there's no role for them. The role I often suggest is something called a trust protector. And what a trust protector does is they're a person that has a management role, but not a day-to-day management role. So they oftentimes, they have some oversight ability over the actual trustee, and they may actually have the ability to hire and fire the trustee, or to review their investments, or to veto certain expenditures. You get to define what they do, but it's something short of day-to-day management. So it's almost like your board of directors and your president, CEO. The president, CEO does all the day-to-day management, and the board just steps in and just sort of watches what's going on. So really great role, and as I said, I'm using more and more professionals. I'm also using more and more trust protectors because I want some oversight of that trustee. All right, so let's switch and talk about ABLE accounts briefly. Another really important tool that's out there for folks who have disabilities. There are some definite limitations on them, but they're a very simplified solution that can really work in a lot of situations. So at its base, what an ABLE account is it's a tax-free account. As a matter of fact, you find it in the same place you find 529 education plans. It's in that same section of the statute. Note, by the way, that it's in an IRS section, meaning that it can grow income tax-free. An individual who is on SSI or Medicaid is allowed to have up to $100,000 in one of these accounts without it impacting their eligibility for benefits. So that $100,000 account is really quite helpful. The story is, though, is that you can only put $15,000 in the account every year. So there's a limit to how much can go in that account every year. Obviously, if you're doing the math on this, it's going to take you a little bit to get to the $100,000 if you don't touch it. But it is a good solution for small amounts of money, for inheritances that are small sums. Those sorts of things can be a really great solution for that. One key to this, though, too, is that the person must be disabled prior to the age of 26. That is the way the law is currently written. Very frustrating for this community in particular, as well as for the brain injury community. They are working to sort of get that number upped, but the law right now says the person has to be under 26 when they become disabled. Doesn't mean, by the way, they have to be receiving Social Security. They just need to be disabled. So if your injury happened at 27, you're kind of out of luck. If your injury happened at 22, you fit within the category. Third is the expenditures that can come out are for things called qualified disability expenses. Qualified disability expenses, though, is broadly interpreted. Basically means anything related to the disability or really anything that increases the person's independence, happiness, and quality of life. I mean, I can't really think of a whole lot of things that don't fall within that category. The interesting part about these, though, with that, is that you put money in this, and one of the things that works as a qualified disability expense is to pay for food and shelter. So you could use your ABLE account to pay for food and shelter. So I couldn't go and pay for somebody who's on SSI directly, pay their rent. But what I could do is I could put the money in their ABLE account. They could turn around and use their ABLE account to pay their rent. So it's this interesting thing that's happening, and it's an interesting interaction now with trusts, actually, where trusts are now using this as a way to give an individual, somebody with a spinal cord injury, for example, some independence and freedom, because it's not income when it comes into that account. They can allow them to manage that money in the ABLE account on their own. They can allow the individual to spend. So qualified disability expenses, and then Medicaid reimbursement is going to apply to these accounts as well, regardless of where the funding is. So if a third party, like a family member, is funding this, just be aware you're subjecting it to Medicaid reimbursement. And then each state has a different program. I've put the website up here for the Washington State program. You can, in many states, go to those others, or you can go to other states and open it. But quite honestly, you're probably just as good with Washington's program. All right, so I've sort of talked about this already. Household expenses, financial control, those are the biggest uses, I think, for these, other than small sums of money. Person saying, what do I do with this money, and get qualified or keep my eligibility for benefits. But really, those bottom two ones are the big ones. This chart just gives you sort of a really brief comparison between this. I know we're right at the end, but what type of attorney would I be if I didn't give you a disclaimer and notice that I'm not giving you legal advice? Yeah, if you do have questions about any of this, please let me know. My contact information is here. I'm more than happy to answer questions. I can also stick around, or if anyone had questions for the group, I'm happy to answer those as well.